Hey, we're live. I'm Greg Siskin. I've joined this week. First of all, I got to get myself in the square. I'm joined by Jesse Bless and Aaron Hall, and no Chuck Cook this week. Chuck is on a cruise. That is the only way you can get that guy off of the internet. Because, well, actually, he could do it, but I don't think he can live stream on it. I think they have prohibitions on where they don't have the bandwidth to do it on there. So he's checking email and doing all that stuff, but he is not here this week, and he has left it to the rest of us to update you guys on what's happening on the cases. I also am logged in on my own StreamYard account, so I don't have all the banners that Chuck has. I have a couple of them on there, but I will do my best. And I've just
Greg, your video is a little blurry. I don't know
why.
Yeah.
Hold on a second. Any better?
No, it's not the light; it's the connection, I think. But it's all right.
Yeah. Okay. Well, I'm gonna let you guys then.
Yeah. Should we take it, Aaron? What are you working on this week?
Well, this week, let's see. What do we have news on?
All right, I'm back. Oh, wait. Any better?
Yeah, I was gonna start, Greg. I think I was gonna start talking about DB 2021.
Yep.
And then, because there's not much news there, and then we can go on to DB 22 and some other cases. So DB 2021, I think everybody knows that the briefing is all done at the Court of Appeals, and that is the Go case consolidated with Gomez, Acker, Good Luck, all of those cases. It's all briefed.
Hang on.
You got the banner up. It's looking
good. I have DB 2022 up.
That works. Oh, no, it doesn't work.
It's the wrong case. Hang on. It's already screwed up. Hang on. DV 2021.
It's amateur hour here without Chuck, but we'll get
okay. By. Hey, there we go.
There we go. So that is briefed. Our expectation, I think, Jesse, is this right, that oral arguments are likely to be set in September? That's what I recall from the order.
Yeah.
So we will not have a decision on that until fall at the earliest, late this year.
Yeah. Yeah, I think the one important point that maybe people don't know is that, we did gain a significant concession, or at least an order from Judge Mehta, that the State Department has to keep working on their internal program so that if we are successful in defeating the government's appeal, we should get to a point where they can start issuing and scheduling those winners or those visa applicants soon after a decision. Now, I say that, and then I personally believe the government, if they're not successful, will try to go up to the Supreme Court and follow the same playbook that they did, where they'll try to stay any order and then see what the Supreme Court will do. So
maybe
go ahead,
maybe, Jesse. Maybe you can give us a little bit of insight, because if I recall right, so the issue when we were first seeing if they were actually going to proceed with the appeal after they had filed a notice of appeal, it was that they needed to get the Solicitor General's buy-in to actually proceed with the appeal. Is that the same process if they want to petition for cert at the Supreme Court, or is it a different process, or what does that look like for inside the DOJ?
Yeah, so definitely the Solicitor General has to. I mean, it's same vetting process. It should be a little bit somewhat easier now. But when you're talking about the Supreme Court docket, the Solicitor General has to be careful, because they don't want to go for too many cases, right? Because Supreme Court doesn't take as many cases. You don't have a right to a Supreme Court review like you do in the Court of Appeals here. So it's a different process and a different weighing of, kind of the pros and cons of doing it versus other cases. I think, just personally, I believe the reservation issue is something the government believes is very important and worth cert. Meaning worth cert. What do I mean by that? Certiorari is the process. You have to file a writ of certiorari to go up.
Why do you think they're fighting so hard on this? Just, I mean, it's it just seems to me it's a hard thing for them to message. If trying to say that they're pro-immigration, if they're basically defending the Trump position here.
Yeah.
And it's at some point, it takes on a much higher profile when this is going to the Supreme Court.
Yeah.
And right now it's obscure. It's only being paid attention to largely by the people that are directly impacted.
Yeah.
Once they decide to proceed with this to the Supreme Court, all of a sudden it's going to be especially if the Supreme Court takes a case, it's going to be something that's going to be in the news, and it's going to be something they're going to have to defend.
Sure. And let me, I don't know if everyone's aware of the Patel decision, but the facts of that case were extremely sympathetic, right? And the government actually tried to get away from cert on that. Nevertheless, I think this issue, they don't, as much as we care about diversity visa applicants, they see it as strictly a legal issue. Whereas, can a judge, not DV people, not the bad attorneys pushing for this, but can Judge Mehta or any federal court go and do something that would that would actually reserve visas where there's a deadline? Can it happen? Can it happen maybe in the green card cases, right? The other employment-based cases. Can that reservation happen where we have a statutory deadline? That is something that's really a, executive authority, congressional authority versus judicial authority, right? Those three branches of government. And we have friends at the Supreme Court actually who actually would say, yeah, absolutely. Judge Gorsuch is one of them, where he would say, well, we can certainly do that. It's within our equitable authority as federal judges to order a remedy. And so it's really about, can we fix unlawful action? And one of the reasons I love our case is because of certainly, I support the federal judiciary. I think they can. But the government would, if their argument played out, would say, we can absolutely violate the law. And if we hold out long enough, there's nothing that anyone can do about it.
And if they lose, doesn't it have much broader implications potentially for them well beyond the DV cases? I mean, the risks are pretty high for the government if they end up taking the Supreme Court and lose.
Yeah, and I thought it was pretty significant they actually went forward. I'm on record of being wrong on the appeal. I didn't think, I thought it was such a bad look for DV 2020 to look at what they did to that program. And they had class cert granted. And this is the Gomez case where I'm still class counsel on with our partners. And, they did it. And that tells me that they've persuaded the Solicitor General that it's so important that they're willing to go forward and risk the loss at the appellate level of getting a precedent decision, because they will be the first one necessarily, right? We have some district court decisions elsewhere. And I think once they're in, they have to be in all the way. That's my theory. Maybe I'm wrong and they don't go to the Supreme Court. Certainly, though, that would be one of the things that the Solicitor General will think about. Hey, listen, I let you have the keys to go to the appellate level, but I can't risk this. Maybe let's try it in a different circuit before we have a circuit split on this.
Well, they're already at risk, I guess, with the appeal on this case, on the visa waste, the green card wastage case that is going to be proceeding this year as well on that. They didn't get to the merits on that, but I would think that if they lose here, that's going to impact that other case too.
Yeah. Well, yeah.
So a couple of follow-up questions. So let's just say they do lose here at the appeals court and they do seek cert at the Supreme Court. Number one, what do you think the chances are that the Supreme Court takes the case? And number two, how long will it be till we know that?
Well, I think they would, the order to start processing the visas would be very quick turnaround, right? So they would have to seek a stay and essentially meet the requirements for an injunction showing that they have a likelihood of success and that they would suffer irreparable harm, right? We've kind of been through this where Judge Mehta granted them the stay. Once you issue the stay, although the standard should be higher at the Supreme Court, I think I'm just cautious at saying, well, even if we win, the Supreme Court wouldn't grant a stay. I don't really know. I think they may get a stay and then the Supreme Court could say, we don't want to rule on this and go away. But certainly until that period, right? I believe it's 60 days, but until we know, anyone who's a member of the Go case or Good Luck case or Gomez class, I just think you just have to live with the uncertainty, because we just don't know. Number one, we don't know what the government's thinking, and number two, we don't know, what the Supreme Court is going to do. I mean, maybe they'll leak out their decision early and we can figure it out. But I don't know.
No, but I think your point up front, Jesse, was an important one. That it kind of went under the radar, but Judge Mehta's order that they need to update their technology system so that they're ready to hit the ground running if and when it's time to start processing these visas should be important.
Yeah.
So a lot of uncertainty.
Yep.
All right. So
what case is next? DV
let's do
2022?
2022.
All right, there we go.
I don't really want to get into a lot. So this is our Ujibor case. I don't want to get into a lot of the weeds on this. I just wanted to let people know. I think last week we had mentioned that we had filed the opposition to the motion to dismiss. And the next steps are likely to get either an administrative record produced voluntarily by the agency or a motion related to some discovery. Like I said, I don't really want to get into the weeds of it, but that's what's going on. Basically, we are looking to get more information that we need to go to summary judgment. So that's what's going on. We should have updates in the coming weeks that are a little bit more substantive, but that's what's going on there.
And it's not Impact's case, but it's Jesse's case. Is the other DV 2022 litigation. And since Jesse, since you're on, why don't you give an update as far as like where that case is?
Yeah, so we initially brought two cases. One was just simply for those in Sydney where the consulate had shut down completely, and one was worldwide. And in our Sydney case, I'm not taking credit for it. It's just the reality was SUVA allowed anyone scheduled in Sydney to essentially reassign themselves to Fiji and get an interview. Not only get an interview, they could actually have a date. And it's the only consulate in the world that I'm aware of that has allowed this process. And I only have 4 plaintiffs left in that Sydney case we started with, I believe, 23. I don't know who deserves the credit. I guess I'm just happy that some of our plaintiffs were able, at a great expense to themselves, take that option. And the other cases, what we've seen from and Aaron, I'm sure this kind of transcends every case, is, after February 1st, which I use as the date we filed, they surged scheduling, and they're going to say it's unrelated to litigation and it was a part of their plan all along. But you know what, though, it actually reveals what's so different this year, which is it's consular prioritization. And there are some consulates that refuse to follow the regulation. Well, I don't know if it's KCC or the consulates, but number one, they're not going in the order that they should be going, and so they're skipping people, to everyone's utter frustration. And the other thing, what they're doing is some consulates are just not playing the diversity visa scheduling this year, and some big consulates like Cairo, Ankara, and then they're being inconsistent. So some months they'll schedule a good number, and then other months they'll let people fall by the wayside. So this year is different, and I've said that from the start, and we need to litigate what's different, what's still unlawful, what's still not reasonable. And I'm just glad that again, it was never, I'm glad that there are other attorneys involved in the space, because they may get to a number they feel good about. They're never going to get to the cap, and they're going to do it in a way where they're going to leave a lot of people who deserve an interview. I'm talking about low numbers, and they're not going to give them that chance. So.
Yeah, I think that's right. The numbers, I don't have them at the tips of my fingers, but the numbers that they call ready from KCC are pretty substantial. The issue is whether the consulate is actually setting the interview and requesting the file from KCC. And that's where it seems to be inconsistent and backlogged. And it makes sense that would be the case, because they cut out a big chunk of the processing at KCC this year for the first time since I don't know, years back, where they're not doing too much the substantive rather than other than reviewing to make sure that the DS-260 is complete.
Yeah, I mean, one of the things that is going to, I think, become an issue as the summer goes on, and it's not related to, I don't believe it's your litigation or mine, but, when you have this process where the documents are being just submitted to the consulate in general, I think it causes a lot more administrative processing cases, meaning that you get put in quote unquote AP, or you see it's refused, and you're in this abyss of who knows how long we'll be there. And I fear that as we get to August, September, people who've actually been interviewed and had that opportunity are going to be crunched against the deadline and have to find another solution to trigger a decision. I hope that doesn't happen, but I'm starting to get a sense that will happen.
Yeah, I mean, in the cases, the Gomez case, the Go case, the judge, said that the prioritization system that the State Department had enacted was unlawful, and that the statute in Congress didn't say that the State Department could say one category of visas was more important than another, even if the State Department likes to think that they have that discretion. And it seems like all they've done is essentially said, well, we're not going to make that decision anymore at a central level, but we're still going to allow every consulate to basically violate the decision on their own. I mean, is that an incorrect reading of it?
Oh, my very oversimplified, and Jesse can tell me where I'm wrong here, but my very oversimplified thought of it is they had these policies and this guidance in place in 2020 and 2021 that basically gutted the DV program. That was found illegal, and they formally took away those policies, but then just said it's up to you, consulates, to decide. And then when they didn't do anything, or they left those policies, basically those prioritizations basically in place, maybe not in writing, but at least in fact, then they still have an essentially gutted program from the prior policies that were with no corrective action having been taken, and they've just kind of taken away the formal guidance for litigation purposes. And so the question becomes, if you've previously gutted a program that Congress enacted, and you don't take any corrective action to get it back on track, is that lawful? Yeah. So I know that there's more nuance to it than that. There's more details to it than that, but that's the way I think of it in my mind.
Yeah, I think they still view everything. Another big push for them was non-immigrant visas. They wanted to get back. I mean, they're on record as saying that. Like, we didn't do, we wanted to go post-COVID into a post-COVID world where we could get back to issuing non-immigrant visas and get through a backlog of cases. And the theory behind how they believe and how consular chiefs have interpreted it is, well, everything's a zero-sum game. And so for every interview we give a diversity visa applicant, that's a slot we can't give to someone else. Now, well, who says you have to have, perimeters on your slots? I mean, you've done it before, and you've actually followed the rules and regulations before. And of course, for non-immigrant visas, I think there's more leeway to excuse interviews, right? But it hasn't in practice. The numbers are telling a very different story at certain consulates, right? So you have like Cairo, who would do, let's say multiples of hundreds of diversity visa applicants per month throughout the year, and they're doing less than 100, right?
Yeah, I mean, I think what's going to be probably interesting this year is that, I think there's this realization that for the vast majority of us, that COVID is something that is not going away. It's going to be around probably for several more years. And the State Department has still, to this day, not really made any fundamental changes in terms of the way that they are proceeding and the way that they can be able to, get back to some kind of normal as far as processing goes. They are not doing video interviews. They're not transferring cases to be dealt with in Washington. They're not really doing anything. My understanding is they still are, at a lot of these consulates, are, at reduced workloads, and where they're not letting people take cases out of the building. They have to work on them only in the building, and in the building itself, they're only allowing people in, at a half capacity at some of the consulates. So they're still acting like it's April of 2020. And at this point, and I don't, at some point, I would hope that the judge is going to ask them, like, what is your plan for the next couple of years to eventually be able to recover from this? Because to date, they haven't done anything as far as being able to catch up, much less get back to a normal capacity.
Yeah, I mean, it's as if they keep saying, we want to get back to the way it was before COVID, but that wasn't good enough either. And then they still want to use COVID as the excuse, and then they don't want to learn what we've all learned, right? We're all on a video from wherever we are right now, and they don't want to learn from that and actually. And this is actually goes for our immigration system in general. They don't want to use the tools we now have and how we can, vet or security. And then they want to move it to a post-COVID world where we're better. And they just want to say, well, there's a backlog. I mean, there was a backlog in the 1990s. I mean, it's time to really get swift with it. And
well, they claim that they can't do video interviews because the regulation requires an in-person interview. But the regulation itself says that can be waived in the case of an emergency, and yet they are still saying that COVID is an emergency, and they use that as the excuse to do most of the stuff they're not doing. So they basically are playing it both ways. It's an emergency when they want it to be an emergency, and it's not an emergency when it comes to using this regulation that would allow them to basically be able to manage a much higher capacity of cases.
Yeah.
All right. That's DV 2022. Let's, Aaron, what's going on with the EB5 cases?
Those are all served. I know Zach's actually working on some of that stuff today. So my understanding is that we are waiting for responses. The government's on the clock there. But that's kind of where that stands.
Okay. EADs, on that, there's any news on that?
Yeah, same as last week. We got this order from Judge Leon asking for additional briefing on the issue of mootness, and so we are working on that. That is due, I want to say June 21st. That is what's going on there. And then the order of what's going to happen after that, according to the judge, is that he's going to rule on the motion to dismiss. If he does not dismiss, then he moves on to class certification.
Right. So just so people are aware of it, because there are a lot of people that are impacted by this issue of adjustment EADs. All of our plaintiffs have gotten their EADs, which is great news for the people that decide to step up and litigate. We're trying right now to win on the issue of class certification still, and that's where the fight is ongoing. The government's saying, well, it's moot because these people have all gotten their EADs. But if we win on the class, obviously, then then we'll proceed and we'll be able to help the broad population. If we lose on this issue, then we will start another case, and we will probably have, given what happened with Kang, where all of our plaintiffs got their EADs, I can't imagine that there won't be a lot more people for the next case. So this. And, I'm not sure why USCIS is not sort of playing this out and realizing that this is just going to lead to a much bigger EAD case that's going to be coming as soon as they, quote unquote, win on this issue on class certification. This issue is not going away, but that's likely. That's the way I'm seeing it as far as what's going to happen.
Yeah.
One point on that, because. John Wasden and I have the H4 L2 petition /EAD delay case, and there, we've been waiting for a class cert and a decision there on that specific type of delay, and the government just non-opt or non-opposed our motion to file a third amended complaint to add more plaintiffs just to take that issue off the table. And wink, wink, I think the judge was saying, like, maybe we can just do that because then it won't be moot. And if you look at it, and I think that the government is, maybe they haven't realized, maybe they should talk to each other, but maybe what they should realize is that their processing times, at least for H4. It almost guarantees, there'll be gaps or whatever, or that, they won't be sufficient, or they'll be waiting much longer than 180 days. Right. And so, and by doing so, especially with EADs for adjustment assess, I mean, that's a it's not like that's just a set number of cases. Those happen, they have their own data set to know that there's more and more coming. Otherwise, the processing times wouldn't be so long. So how they would say that it's not repetitive, or that you couldn't just go out and file a new case, is beyond me.
Yeah. All right, moving along. The next one I have on my list is the one we're onboarding right now. So this is visa wastage. This is I call it Chakrabarty Part 2 because we don't have a name yet for this case, but basically this is we are onboarding right now for people that are at risk of, if the government is not able to adjudicate enough employment-based numbers this year. I don't have to get into all the facts. The people that are here for the information on that case are aware of it. That is, so we are. The one thing I will remind people of is that if you were in the case last year, you do not need to pay to be in the case this year. The only thing that I would ask is that you go to our onboarding page and fill out the engagement letter and fill out the declaration apps, and then don't make a payment. Send me an email. You guys know how to find me if you were in the case last year. And we have on our little spreadsheet a little column for people that were in the case last year that are re-signing up. And if you send me that and you've gone through filling out the apps, you will be in our database. You'll get the communications, and you won't need to pay to be in the suit this year. The deadline is coming up in about 2 weeks. For joining that case. I haven't done that much publicizing it. I'm going to be starting to be doing more of that starting today. But if you want to be in that case, that's the address. Take a picture of the address with your camera, or write really fast. But that's that being said, I'm looking forward to having actually getting to the merits on this case this year, and not having the venue issue that we had last year. We talked a lot about that last week.
Yeah, I was just going to say we've had a few people reach out and just say, can't you, I was in Chakrabarty, can't you automatically enroll us? And no, we can't. We can't.
Well, we don't know who's gotten some people actually have gotten their green cards.
Right. And even if they haven't, we can't file a lawsuit on their behalf without them directing us to. So
right.
We do need
it's not that, right. I think that we actually had an email go out to the old plaintiffs on that, but it's not that hard. But you can spend 15 minutes on this, and you're in the case again on that. I don't think it's that much to ask. But that's what's going on with that case. And I think that is it. We can go to questions. We have our first question from, I hope I pronounced your name right, Celine. And let's see, your DV 2022, ANCRA and KCC is being in the suit a priority for you.
Yeah, Celine, I think she's asking whether there's any information in the government filings, maybe about her personally.
Right.
I don't want to talk about anybody's case here, but if you email me, aaron@immigrationissues.com, if you do that, then I can get back and let you know what, if anything, is said.
Yeah, and I don't know if she's touching on something that was posted, and the government has released this in their November 2021 guidance. They have a bullet point where they say that litigation or it is a priority, and some others have interpreted it one way to mean like, oh, if I file, I'm a priority. I can tell you, I've spoken with the people who were behind drafting that at the government, and that is not what it means. It means that if they have a court order, they have to treat the order as a priority. So that if Impact wins a lawsuit and you are a plaintiff in that lawsuit, they have to and it's against the Department of State and involves consular processing, that has to be a priority for the department. But it's not as if listen, I'm a litigator. If that were the case, it'd be great for me if they did do that. But and they prioritize when I file a lawsuit. That's not exactly how it goes in that written agreement. Now, outside of the DV space, outside of everything, when you file a lawsuit, you certainly get their attention. But that specific guidance does not mean that the department always treats plaintiffs as a priority.
All right. So we got some good news from Jason, who his fiance has arrived from Manila, and Mazel Tov.
That's great news. What a long road, Jason. I'm so happy for you. It's been that has been so long, and it just shouldn't be like that. You shouldn't have to go through all this to be together with your fiance or spouse. So finally, I'm glad you guys are happy together.
Yes. So very nice to hear that news. All right. So I guess Aaron, you're being confused for Jesse. You're being confused for. Oh, you're the next gentleman's name.
I'm the next. I'm happy to be that next gentleman too.
On there, you got through with the green card based on the EW3. It took 7 weeks after you entered the U.S. Okay, very good to hear that. And then let's see. I guess the question is DV 2020 and 2021. Is there any news in Congress? So. Jesse, on these calls, sometimes I will do an update as far as things that are happening in Congress. I think are they on recess right now? I think they might be, but there's nothing really fast moving that I'm aware of as far as any legislation. The only thing that happened recently was the Ukraine supplemental bill. If you're Ukrainian, this is the one thing that, and I was actually getting a lot of questions about this. So just so you guys are aware in your practices, in this bill, it said that anybody who enters on parole status from Ukraine is to be treated as a refugee. Now, from if they came in between February 23rd and like sometime next year, that opens up a whole range of benefits like healthcare and employment authorization. Refugees are employment authorized the moment they enter the United States. So the big question I'm getting is, am I, because of this law that's the president signed a couple of days ago, if you are coming in on the Uniting for Ukraine program, and there's like 10,000 people a week coming in on that program, do they need an EAD or are they automatically employment authorized by virtue of this statute? That's this new law that's come in, and USCIS has not said anything about it. Might be ripe for litigation at some point if they decide to take a hard line on that issue, because if they're to be treated as refugees, they should not need to have a separate employment authorization document for that. I do not believe refugees have to have that in order to be entitled to work right away when they come into the United States. But that's something I'll need to do a little bit more research on, but I think it's an interesting question. Otherwise, there's nothing imminent legislation-wise that I know that the Healthcare Workforce Resilience Act continues to get more sponsors in the House, and there's some of that kind of stuff happening, but there's nothing that is as a vote that's imminent that I am aware of. Okay. Could President Biden do an executive order to recapture unused DV visas? That's if the president was so inclined. I don't think he could do it on his own. I think it requires a judge to order it, which has happened, at least for a partial number of it. But
he could tap his. The Department of Justice is an executive branch, and so is the Department of State. So he could tap his friends on the shoulder and tell them to drop the appeals. That would be a lot easier.
Yes, you could do that. I know that actually there is legal theories on the visa wastage that that they have the authority to do that on their own without a court order. They were given there was a I forget who had sent. Maybe it was Paul Hughes had
it
written
was
a good memo.
Andy Pincus did.
Oh, Andy Pincus did. Yeah,
It was brilliant too.
Laid it out like, here's how you do it legally.
Yeah.
It was really well done. And then, of course, the intransigent people within the agency said, we don't care. Even if you give us the legal justification for doing it, we don't want to change because that would be inconvenient. That's essentially what I understand happened behind the scenes on that. All right. Where document? Oh, it's question is that there's documents still in place for DV 2023. I'm not sure I understand the question.
I think the question is whether the pilot program that essentially allowed just people to be scheduled without submitting their documents to KCC, they just submit them later, whether the pilot program is continuing. And I think it's actually.
Do we know?
Excuse me?
Do we know the answer?
Well, Britt Simon, who's an expert, who's believes that it is not the case that you can just submit your 260. You actually have to submit everything. But people have asked KCC for their position on it, and so far they have no confirmation.
Well, if there's no announcement, then I think you have to submit your documents, because the announcement that came out was very specific that it was for DB 2022 only. So.
Okay. All right. And the last question I think we had here was something that was very case specific to Pratish Madhavan, who is one of our Chakrabarty plaintiffs. So I'm not going to bring that up, but I think we can end a little early today. I know that people probably are here that they're missing Chuck this week, who should be back next. I don't know how long his cruise is, but I can't imagine he's going to stay offline that long. It's just not in his nature. So he will be back. Congratulations, Jesse, on your Boston Celtics.
Thank you.
Congratulations on your Colorado Avalanche. They're still in it, right?
Oh, we're going all the way. We're going all the way. Game 1 tonight against Edmonton. So
yeah, there are no Tennessee teams that are left, except my Vanderbilt Commodores made into the College World Series tournament. I'm happy about that. But that's about as good as it gets these days in Tennessee. Anyway, we'll end there. We'll be back next week. And then just so you guys know, I am going to be, Ian Wagereich and I are doing a bike ride for 4 days in New York right before the ALA conference. So I will not be on while I'm on my bike ride on there. But next week I should be here. Jesse, if you could stay on for just a second afterwards, I want to tell you about a case. Aaron, I'll see you next week.
See you in New York.
All right.
All right.
Take it easy. Bye-bye, everybody.